In court after an admitted killer is caught on camera smiling during his sentencing. A judge fed up with that casual attitude stopped the proceedings in a surprising move. 7 Action News reporter Shelley Childers live in the newsroom right now with what happened next. Shelley?
Well, Stephen, it's a case of a murdered Ann Arbor teen, and it was quite a shakeup in court today. The judge asked the prosecutor to throw out the sentence agreement and take this case to trial. There was a long recess as everything was put on pause because of this 17-year-old's behavior. Donta Wright sat in court smiling and nearly laughing as a mother shed tears for her son, shot and killed by Wright.
I've lost laughter and love. I no longer have the hope of having grandchildren. I've lost the enjoyment of holidays and birthdays and of everyday life.
Wright addressed the court showing no remorse.
I just want to tell y'all, I'll be home soon. R.I.P. Keon, I love my family.
That's all you got to say?
Yes.
The judge, clearly fed up with the defendant's attitude, stopped the proceedings and asked prosecution to consider taking this case to trial, where Wright would face a stiffer punishment if found guilty by a jury.
But watching you sit there, smile, and laugh, and shake your head like this was no big deal, I'm very tempted to just say, I'm not going to accept this sentence agreement. We'll go to trial, and if you're convicted of felony murder, you'll go to prison for the rest of your life. That means you'll die there.
This is not the first time the teen has shocked the courtroom. Back in June during a pretrial hearing, he admitted he shot and killed 18-year-old Jordan Klee. It was October 2016. Wright said he and 2 other friends were trying to rob Klee when he shot Klee in the back of the head, killing him. The victim, a senior at Pioneer High School in Ann Arbor, was described as a high-achieving student and football athlete.
This year was supposed to be a year of celebration, of senior pictures with prom and graduation and parties. Instead, it was a nightmare that no parent should ever endure.
Ultimately, Jordan's family decided not to take this case to trial and to move forward with today's sentencing. The defense attorney apologizing on behalf of the 17-year-old.
His smiling was in no way meant as disrespectful either to the family, to the victim, or to this court.
Donta Wright was sentenced to 23 to 50 years for armed robbery, felony firearm, and second-degree murder of 18-year-old Jordan Klee. And in court, we also learned that Donta Wright is accused of being part of the finesse gang from Ypsilanti. The other 2 people charged in this case have also pled guilty for their roles. Delreno Gracie and Jeremiah Ellison are scheduled to be sentenced in September. Reporting live in the newsroom, Shelley Childers, 7 Action News.
Thank you, Shelley.
I would submit that this case is probably the most difficult and shocking case that this county in St. Johns County has dealt with. In the 20 years that I have been, or 16 years that I have been practicing law, and the 30 years that I have lived and worked in this, all of Northeast Florida, this case is one of only a very small few that had this level and this type of impact on the community. This court gives this factor great weight. As to the last 2 remaining factors, the effect, if any, of immaturity, impetuosity, or failure to appreciate the risks and consequences of the defendant's participation in the offense, and the effect of the crime, and the nature and circumstances of the offense committed by the defendant. These factors are somewhat combined. 114 stab wounds, 49 defensive wounds, 35 wounds to the head and neck, 29 to the back and shoulder, and 6 fatal wounds. This court has reviewed and seen more than its fair share of autopsy photos. The autopsy photos in this particular case were particularly difficult. The 49 defensive wounds indicate that Tristyn Bailey was conscious, that she was aware, and that she was doing everything she could to fend off this attack. She suffered a painful, horrifying death from someone that she trusted. Her screams were most likely stifled by her own suffocating lungs. He lured her into a secluded place in the woods near his home, a person that she trusted, and he led her there under false pretenses. There was a heightened level of premeditation in this case. Based on the prior statements that he made to his girlfriend and his friend, he indicated that he was going to kill someone. At which point he determined that it was going to be Tristyn Bailey, I don't know. But there was going to be a victim. He indicated that how he was going to do it, that he would take them into a wooded place, that he would stab them, he would kill them and then run away so that he could keep on killing. He told his best friend that he wanted to kill someone to see what it felt like, and he wanted to watch them bleed out. This particular crime was committed with the weapon of choice as a knife, which he nicknamed Poker. That required a up-close, personal, type of murder that is rare. It's unique. The court accepts that in 2019, of all juvenile arrests, only 7% were violent and only 1% of those were homicides. This crime is clearly an outlier, and it was shocking, and it is shocking to the conscious. This court finds that the defendant's participation in this offense was not the result of immaturity or impetuosity. He understood the risks and consequences of his actions. He previously told his girlfriend that he was going to do this. That clearly shows that he had been planning it. He attempted to cover it up by disposing of the murder weapon and throwing it into a lake. He then attempted to conceal evidence by hiding his shoes and shirt and jeans, taking a shower, stealthily entering his home, and then the actions immediately after, with the Snapchat videos in the back of the police car and the story that he made up about pushing her and her hitting her head, which was clearly refuted by the video evidence in this case. All of that shows, and this court finds, that this was not an immature or an impetuous type of crime. It makes it unique. It makes it extraordinary. What is also very troubling is that this crime had no motive. This was not done out of greed. It was not done in retaliation, retribution, or revenge. It was not a crime of passion. It was not a crime that was committed because he felt rejected by her. It was not done in a fit of uncontrollable anger. There was no reason. There was no purpose. It was done for no other reason than to satisfy this defendant's internal desire to feel what it was like to kill someone. It was committed in a cold, calculated, and premeditated manner without any pretense for moral or legal justification, and it was heinous, atrocious, and cruel. This factor and this factor alone makes this case and this defendant more than just unique. It is for this reason and all of the reasons previously stated that leads this court to the conclusion that there is only one appropriate sentence in this case. Mr. Fucci, if you and your attorneys would please rise. Counsel, is there any legal reason why this court cannot impose sentence at this time?
No, sir.
Mr. Fucci, having entered a plea of guilty to the crime of first-degree murder, I adjudicate you guilty of the premeditated first-degree murder of Tristyn Bailey. I sentence you to life in prison. Because of your age, you are eligible for review of the sentence in 25 years. I order the Department of Corrections to notify you when you are eligible to apply for your review hearing. Madam Clerk, if you will please impose the minimum fines and court costs. Mr. Fucci, you have 30 days to appeal the legality of this court's sentence. If you wish to appeal but cannot afford an attorney, one will be appointed for you. You will be taken back to the Duval County Jail and then transported into the Florida State Prison System. We are adjourned.
I am not sorry for something I didn't do, and I am not sorry for the things I did do.
Mr. O'Neill,
All right.
Listen, stop.
All right.
Listen to me.
I'm not
You're not going to raise your voice again.
I'm not going to raise my voice again. I'm not.
I will have you removed from this courtroom. I can sentence you without you being present.
Yes, ma'am.
You don't conduct
I
yourself.
understand, Your Honor.
Thank you.
But I will say, I'm sorry for your loss.
19 years I've been at this job. I've seen human beings killed at the hands of others in every way imaginable. You name it, I've seen it. Shootings, stabbings, drownings, suffocatings, blown apart by cars, some DUI manslaughter cases, horrible things. This is the worst case I have ever seen as far as the facts go. When the person from fire department, when he testified, and when he said that he retrieved the body of Ronivia O'Neill from the home, and all he could do was sob. It took every ounce I had not to start sobbing too. Because there is no way any person with any feeling could have witnessed or seen the photos of what occurred that night and not be haunted for the rest of your life. I know I will be. For the rest of my life, I'll be haunted by what I saw as far as the evidence and just the abject cruelty of it all. The abject cruelty. And I was aware, because I reviewed a lot of the discovery ahead of time, as you well know, did a lot of in-camera inspection of a lot of documents. And I was aware there was some evidence, at least, that when you needed to recover from your gunshot wound, that neither your parents nor your Aisha, Ms. Robinson, would let you come recover at their home. I don't know if it's true or not. I'm not going to get into a dispute. I'm just mentioning there was some evidence referencing that in the records. And all I could think about, because I knew that Miss Barron was not with you romantically at the time. And I knew that she just, out of the goodness of her heart, let you come stay with her. And it is beyond tragic that that critical decision ended in so much horror for her and for her children. It is unspeakably cruel what happened as a result of that one decision. The way that Ms. Barron died was horrific, and that 911 call, which captured truly all of it. You heard, and everyone who's heard that 911 call heard a death scream. If anybody ever wants to know what it sounds like before a human being dies, knowing that their death is imminent, that's exactly what it is. That was a death scream.
We're going to see if it's true.
But what happened to little Ronivia and to little Ronnie, but I'm going to focus on Ronivia because she was special. And you could tell Miss Barron had done everything she could to create a beautiful home for her family. I noticed that the Ronivia's bedroom, before you set it on fire, you could tell she tried so hard to make her feel like a princess. Kenyatta did everything she could. And I noticed too in the kitchen on the refrigerator, she put up magnets that said faith, love, family, hope. And then you know what else happened at the refrigerator during that night? It got splattered with blood all over it due to what happened. Little Ronivia, she couldn't scream, she couldn't run away, and she witnessed what you did to her mother as far as shooting her mother in the arm with the gunshot. She knew. And the horror that that child suffered. And she already had a life where she was born with challenges regarding her physical and her mental disabilities. But the pain and suffering that she suffered that night at your hands, unspeakable, absolutely unspeakable. And at the moment, that first time you struck her with that hatchet, and little Ronnie testified that all he could see was tears coming out of his sister's face. At that moment, that child knew. She knew she was being betrayed in the cruelest, most tragic and sorrowful way that a child could ever be betrayed. She was being betrayed by her parent, the one person that should be there to protect their children and love them and keep them from harm. And that was the last thing that child felt before she passed on from this earth, was your utter, cruel betrayal to her. And I read somewhere, and I don't know if it's true or not, I have no idea, but I read somewhere that souls pick their lives, and that they know exactly how difficult their lives are going to be before they enter into this world. And I don't know if that's true or not, but if it is, Ronivia O'Neal is one of the bravest souls I have ever come across in my 54 years on this planet. One of the bravest ever, ever, because she suffered so traumatically.
This trial is a culmination of decisions made by one person, the defendant. Those decisions have forever altered the futures of 3 families, and of you also, Mackenzie. And your decisions forever robbed Dominic and Davion of the futures that they had before them. If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important. Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt. As I previously stated, I considered all the evidence presented, and at this point I would like to comment specifically on Exhibit 802, the crash video. This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of 2 people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day. Exhibit 802 crystallizes the deadly decision-making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. Mackenzie alone chose the time to make the drive, early in the morning, when any reasonable person would expect that few people would be nearby to witness it or offer life-saving assistance. She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her, other people, other cars, pedestrians. She had a mission, and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day, and she alone made that decision for Dominic and Davion, and she continuously acted in a manner to achieve her purpose. Whether or not she intended to also kill herself is a matter of speculation. They have no relevance to the weighing of the evidence in this case. The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022, and her purpose was to kill Dominic Russo and Davion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder. Court renders the following verdicts. Count 1. The court, having had count 1 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02a, is charged in count 1. Count 2. The court, having had count 2 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.02a, is charged in count 2 of the indictment. Count 3, murder. The court, having had count 3 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, as charged in count 3. Count 4, murder. The court, having had count 4 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, is charged in count 4. Count 5, felonious assault. The court, having had count 5 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11 of the Revised Code, is charged in count 5 of the indictment. Count 6, felonious assault. The court, having had count 6 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11a2, is charged in count 6. Count 7, felonious assault. The court, having had count 7 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a1, as charged in count 7. Count 8, felonious assault. The court, having had count 8 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11a2, as charged in count 8. Count 9, aggravated vehicular homicide. The court, having had count 9 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.06a2a, is charged in count 9. Count 10, aggravated vehicular homicide. The court, having had count 10 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.06a2a, is charged in count 10. Count 11, drug possession. The court, having had count 11 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of drug possession, in violation of Ohio Revised Code Section 2.11a as charged in count 11. Count 12, possessing criminal tools. The court, having had count 12 tried to have pursuant to waiver, finds the defendant, Mackenzie Sherrillo, guilty of possessing criminal tools in violation of Ohio Revised Code Section 2923.24a as charged in count 12. The court, having had count 12 tried to have pursuant to waiver, finds the defendant, Mackenzie Sherrillo, guilty of possessing criminal tools and further finds the defendant did intend to use a substance, device, instrument, or article, to wit, a digital scale, to commit the offense of a felony. Sentencing will be 1 week from today, August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.